Okay.
Shut my phone.
Hi, welcome everybody. We are just waiting for some more attendees to come in, then we'll start our legal informational webinar. Okay, so welcome everybody to this legal informational webinar series. My name is Shira Pomerantz, and I'm the director of Project S.A.R.A.H. Project S.A.R.A.H is a New Jersey statewide resource helping those affected by domestic violence and sexual abuse. And it's our members of our women's support group who shared that it would be helpful to receive a refresher about legal information and procedures. So it's thanks to their feedback that we are hosting this legal information webinar. I also want to thank Susan Wiesen, an attorney on Project S.A.R.A.H's advisory board, who connected Project S.A.R.A.H with Northeast New Jersey Legal Services. We're very grateful to Northeast New Jersey Legal Services for partnering with us to provide this webinar. And of course, thank you to NNJLS attorney Angela Rodriguez for being with us today, along with her colleagues, Jennifer Donnelly and Esther Aparicio. We look forward to hearing from you about basic family law. And I was in touch with Angela, who said it would be okay with anyone who has questions to insert them in the chat box, and she will try to get to as many questions as possible. Okay, Angela.
Thank you so much, Shira. Good afternoon, everyone. Thank you for joining us today. My name is Angela Rodriguez, and I'm an attorney with Northeast New Jersey Legal Services. I have presenting with you today Ms. Jennifer Donnelly and Ms. Esther Aparicio, who are both attorneys in our family unit as well. I'm going to, in a moment, share our PowerPoint presentation so that you can follow along. And if you have any questions, we ask you can certainly put it in the chat group, but we do ask that if anything, wait till the end of the presentation. I'll be monitoring to make sure that if your question isn't answered, it's answered at the end of the presentation. We have a lot to cover. We also have a second presentation on February 11th for divorce. So if you have questions regarding divorce and the presentation runs a little longer, you certainly can ask or hold off the question until next session. You guys can also email Shira, and we can always follow up and make sure that we answer any questions we don't get to this time on the next series. Okay, thank you so much. I also ask that any questions that you may have, that they be as general as possible, because there's no attorney-client privilege that's being created here. This is very general law. It's meant to be an informational session, so that if you have specific questions, you can certainly contact Shira. She'll send a referral and we can consult separately with you as long as you qualify for our services. So thank you so much, and let the presentation begin. I'm going to do a share screen. And I'm also going to mute myself.
Okay, I guess I'll start. Thank you everybody for having me, and hope everyone is staying safe and warm in this crazy snowstorm today. And thank you again to everyone for having us today. So I'm going to get us started with the first portion of the presentation today. Again, this is a basic family law training. And again, Angela is going to be monitoring the chat. So if you have any questions while we go through, I do find though that there are usually questions that are answered as we're going through the presentation. So, all right, so first we're going to start off with custody and parenting time. Angela had gone past the slide before. This is just a really basic overview of the different types of dockets that can be filed in the family court. So depending on what sort of legal issue you're having, that's the type of docket that the court will assign you when you file for whatever relief it is that you're seeking from the court. And you could see there's a good amount of them there. Many of them aren't used as frequently as others. Adoption, juvenile family and crisis courts, not used as much, or we don't see them as much in our practice. But you'll notice the FD docket is for non-dissolution matters. That's for child support, custody, parenting time. If you don't have a divorce pending, that would be, if you see a little further down the page, an FM docket. Think M is matrimonial. And then you'll see domestic violence is FV, V for Victor or violence, and FO is other. Those come up much more frequently than the other ones. So we can move on and start talking about custody here in New Jersey and parenting time. You'll see the statute there, NJSA 9:2-4. That is the statute that governs here in New Jersey, parenting time and custody. So courts start off with the premise that both parents have equal rights to custody of the child. So that's where they start. When a mom, dad brings a application for custody in New Jersey, they start off with the premise that both parents have equal rights to custody. And to evaluate who should have custody, all courts use the best interest of the child standard. So we're making a determination about custody. What is in the best interest of the child? Who should the child live with full-time or most of the time? But that's what every court must look at. And when they talk about the best interest and they're making a determination, the court has to put on the record in the decision what those factors were that the court considered when making this best interest determination for the child. Now you'll see there under custody is temporary. We have clients come to us all the time with orders that say that they have temporary physical custody of the child and they get upset. Well, why is it temporary? Why isn't it permanent? There is no such thing as permanent custody here in New Jersey. All custody is temporary in nature. And the reason why that is because people's lives change. So custody by nature has to be temporary. You know, people move, people pass away. So again, if you see an order about custody and it says temporary, just know all custody in New Jersey is temporary. Now there's two types of custody in New Jersey. There's legal custody and there's physical custody. Now, legal custody involves the big decisions made for your child. When I mean big decisions, I mean major medical decisions. Your child's other parent has parenting time, you're away on vacation, your child has an accident and has to have major medical surgery, that parent is able to sign to have that procedure done if you're not there. Legal custody also allows parents to look at pediatrician records, school records. Other big decisions are college. You know, your child gets into Yale and Harvard, and you both need to sit down and figure out what school you think is best for your child. So legal custody, again, big decisions. Joint legal custody is awarded most of the time. 9 times out of 10 courts give joint decision making to both parents. Sole custody is in more exceptional circumstances. So 9 times out of 10, you'll see joint legal custody. Now, physical custody, also known as parent of primary residence, is where your child spends the majority of their time, where they go to bed at night, where they have their meals, where they leave to go to school. And that can be either sole, one person has that, or it can be shared. There can be 50-50 physical custody split. Some parents do it week by week, some do 3 days on, 4 days off. It's not as common to see shared physical custody, especially if parents do not live close to each other, because you have to realize there's school issues, where's the child going to go to school? We don't want to have a child if one parent's up in, Bergen County and the other one's down in Ocean County. How are we going to flip-flop the child? It's a lot on the child. So again, going back to best interests, you and your child's other parent may want split custody, but that might not necessarily be in the best interest of the child. So always remember that. And any other custodial arrangement. Listen, if you two can come to an agreement and to a parenting time situation that works for you, courts love when you have an agreement that you can bring to the court and they don't have to make the decision. And that can be done just between the two of you, and you simply want to put it on the record or through mediation. But you can certainly bring an agreement to the court. So now we're going to talk about parenting time, also known as visitation. Visitation became sort of not politically correct to say anymore because the thought is parents don't really visit with their child, they parent them. So we call it now parenting time. And again, much like custody, both mom and dad have protected rights when it comes to spending time with the child. And the parent with custody has an affirmative right under the law to encourage positive visitation, positive parenting time, positive relationship with the child. And you'll see there's a case there that actually says that. Now, we talked about the best interest factors for custody or parenting time. There they are. They're laid out in statute, and these are the factors that the court will consider and must consider when determining parenting time or custody. And you'll just see them there. Some don't apply, but fitness of the parents is certainly one of them. The parents' ability to cooperate. So if you and the other parent just simply can't sit down, or the other parent does not wish to sit down and work things out with you, the court will take that into consideration. So be careful. The unwillingness to allow the parenting time. If you're withholding parenting time from the other parent, be careful, because the judge is going to consider that. History of domestic violence, also very important. There's a violent relationship between the parents. It's not a good idea to have them communicating, especially if there's a restraining order in place. They actually are not supposed to be communicating at all. Needs of the child's education. If your child has special needs and is in a program in their school that's wonderful for them, and custody wants to be switched, or there's some factor involved with parenting time and your child has special needs that the other parent can't meet, again, something the court will consider. And you'll see also the geographic proximity of the parents' homes. We talked about that a little bit. Parents' employment responsibilities. If you're out of the home, you're a busy attorney and you're out of the home, 12, 16 hours a day, that's probably not the best situation to be the parent of primary residence, because you want your child to be with the other parent as much as possible. So those are the factors that the court will consider when making parenting time or custody determinations. Okay, enforcing that custody or parenting time order. You've gone to court, you've got your order for custody or parenting time, either from the judge or you mediated it, and something's come up down the road. Somebody is not abiding by the terms of the agreement or the court order. What can you do? Well, you can file what we call a motion with the court to enforce that custody or parenting time order. And you would let the court know in your motion what's going on. So I'm supposed to have parenting time, alternate weekends, and one overnight during the week. I keep going to show up. The other parent's not making the child available. I need my order enforced because the other parent isn't doing what they're supposed to be doing. And some of the things that can quote unquote happen to that other parent, if they're not abiding by the court order, you can see there. They may be given makeup time. So you've missed 4 or 5 weekends in a row. The judge is going to say, well, you're going to make up that time. There could be economic sanctions. The judge can institute a fine. They can change the pickup and drop off arrangements if that's becoming the issue. They may suggest a pickup and or drop off of the child in a public place to avoid confrontation. Sometimes this is done at the police station. Courts don't love to do that because they don't want the child to see the police station as a negative. So sometimes we could do it at like a McDonald's, something like that. Counseling for the child if necessary, or the parents. Courts can change if it's really an egregious violation. Courts can change custody if you're not complying with the court order. Incarceration, that's a last resort because obviously that's very severe. There could be a warrant that's issued for the arrest of the person if there's further violation that could automatically kick in. And any other equitable remedy that the court may see as just or fair. Now, either party can submit an application to change or modify a parenting time or a custody order or a settlement agreement. But if there's an order already in place, either the judge gave you that order or you agreed and that agreement was made a court order, you have to show 2 things. So obviously, we're going to go back to that best interest standard. Yes, any change to parenting time or custody will be again looked at through that lens of the best interest standard. But if there's already a court order in place, the person seeking the change has to show that there's been a significant change in circumstances since that last court order was entered. And you'll see the case there that says that that's what has to happen. The reason why that has to happen is because the courts don't want to enter an order or enter an agreement as an order, and then 2 weeks later, somebody comes back and says, well, I want to change the parenting time. And the court would now have to reevaluate under the best interest standard. Because the court wants to avoid that happening, they now say, well, look, what's changed since 2 weeks ago? And sometimes something significant has changed. Dad gets a job out of state and he had custody. That's a significant change in circumstances. All right, so now we're going to talk, we talked about custody, parenting time. Now we're going to talk about child support. Who can bring a request to the court for child support? So it could be either party, either parent, or an agency that may be assisting the parent who has custody of the child. So this comes up in situations where, say, mom has custody, mom is receiving welfare. Welfare would pay mom the benefits, but then would go after the other parents to pay back the monies that welfare is providing to the parent who has primary residence. Now, parties who have a child but were not married will file under that FD docket. You remember we looked at that list of dockets before. Not married is an FD docket. If you are married and in the process of being divorced, or you are divorced, you'll have again that FM docket. That's where you would file the request for the child support. So never married, FD, married in the process of divorce or already divorced, you're going to file under your FM docket. So you know that you can file for child support. Where do you file for child support? You file for child support where the child is domiciled, which is a very fancy way of saying where the child lives. That's the venue. And so if your child is living in Bergen County, you would file your request for child support in Bergen County. Now, there are filing fees really for almost all applications in court, in family court, for the majority of them anyway. Those fees can be waived. If you can't afford them, you would make an application to the court saying that you can't afford to pay the fees and you would like the court to waive them. Or if you're represented by our agency, we do not have to pay filing fees. Our clients do not have to pay filing fees. So there's no fee associated with those filings. Now, to file for child support, what do you need in order to get that application, get that ball rolling? So again, never married, you're going to file under that FD docket number. Once you file, you'll see the application packet says explicitly at the top, this is an FD. This is not for people who are married or in the process of divorce or who are already divorced and already have that FM docket number. Again, you file under that FM. But you file that initial FD application motion with the court. There's a financial statement that you have to include. It is part of the packet and it gives just very basic financial information about your income and expenses. And then you have to file what's called the confidential litigant information sheet. We call that the CLIS. That provides very, let's say, personal information. So it is important that you realize when you file that CLIS, you only send it to the court. The other parent does not get a copy of that. It goes to the court only. And you'll see when you look at that sheet, what I mean by personal information, it asks you for things like your date of birth, your height, your weight. So again, the CLIS only goes to the court. If you're already filed for divorce and you want to file for support during the divorce process, you would file what we call pendente lite relief. That's a fancy Latin word, which means in the meantime. So you filed for your divorce. In the meantime, you need child support. You have your FM docket. You file for pendente lite. You'll see there's a form to do that as well, a packet to do that as well. And you also need to file, instead of the financial statement, a case information statement. Case information statement is much more lengthy than the financial statement and asks not only about your income information, but also asks you very specifically about your monthly expenses, your tax deductions, things like that. It's a pretty long document, about 12 to 15 pages. So make sure you include the CIS, because if you don't, the court's gonna rule your filing deficient. All right, so when does child support end? This law that governs the termination of child support here in New Jersey changed not that long ago. I want to say maybe within 6 or 7 years ago. It used to be that the burden was on the parent who was paying the child support to go to court at a certain point and say, my child no longer needs my financial support. They're grown, they're married, they're in the military. I'd like to file to emancipate them. And that put the burden on the non-custodial parent to do that, and it was difficult. So now what happens with the change of the law, child support will end at 19. And the custodial parent gets a notice in the mail that child support is going to be ending at 19, unless they prove to the court with written documentation why the child support should continue past 19. The majority of times, the reasons why the child support should continue beyond 19 is the child is in college and won't be getting out by the time that they're 19. And again, sometimes, there's other factors why the child support should continue beyond 19, but that's the most common reason why. Now, if the other parent disagrees with that, they can certainly file an application saying, well, they may say my child is enrolled in college, but really they're only taking one class 4 credits every other semester, that's really not enrolled full-time in college. They have to be enrolled full-time in college in order for the child support to continue. Regardless, child support ends at 23, and that's it. It does not continue indefinitely. Sometimes there are situations where financial maintenance can be sought for a child who's over 23. You see that happens if the child has a severe disability and still needs the financial support, but that will not be handled through child support anymore, will not be handled through the family court. Probation is no longer involved. Probation is the entity that can collect and monitor the child support if the two of you don't have a direct pay. But child support in that form through probation ends at 23 regardless. So ending child support, if the parties have more than one child and one child becomes emancipated, what happens with the support order? How is it recalculated? Well, it actually depends on the wording of your child support order. You'll see there's 2 types of child support orders there, unallocated and allocated. In my experience, the majority of the time I see unallocated child support. What does that mean? Well, if you have 2 children and $100 a week child support order, and it doesn't specifically say in the child support order, child A gets $50 and child B gets $50, then it's unallocated. It's just $100 a week in child support for both of your children. If child A becomes emancipated, that $100 a week for child B continues until that child is emancipated. So the amount does not change. If your court order says, yes, it is $100 a week, but child A gets 50 and child B gets 50 and child A becomes emancipated, the $50 a week for child B will continue until child B is emancipated. I hope that was clear.
Yeah, so the only difference there is that, and it could become a big difference, is allocated means that once the other child drops off of child support and there's one child remaining, the child support will be reduced because it was apportioned accordingly. Whereas if you have it unallocated and it's just the amount covering both children, when the older child is emancipated and drops off, the amount continues the same for the younger child.
So once the obligation is terminated because your child becomes emancipated, any arrearages that may have accrued will remain. They don't go away. So if the child's other parent was behind in their child support at any point, and there, for example, remains a $2,000 arrearage amount or amount owed to you from back child support, that amount continues even once that amount remains even once your child is emancipated. And that's paid back at the rate of what the child support was until that's done and over with. So that continues to play. Sometimes you'll see in child support orders, if there's especially if there's a significant amount of arrears, the court may at one point adjust your child support to add what we call a plus order. So if you have $100 a week in a child support obligation and there's $2,000 owed in arrears or $10,000 owed in arrears, the judge can say, I'm going to make the child support $100 per week plus 25 toward the arrears. So that kind of helps knock down that arrearage and it's not just sitting there. Hopefully, and we do see sometimes that parents are able to come up with a lump sum. Sometimes they're ordered to come up with a lump sum to pay to help knock down that arrearage amount. But again, most important here with this slide is to know that even though your child support obligation going forward ends, the obligation to pay those arrears remains until they're paid off. Now, if you have your, again, this is like enforcing your custody or parenting time order, you have your order for child support in your hands, and you got it under the FD, non-dissolution, non-matrimonial, you would file an application under that FD docket to enforce your child support order. Again, if you have the FM, you file the notice of motion to enforce an order. Now, it's also helpful, I think, to point out that if you have probation sort of monitoring your child support account, and that parent, the other parent, becomes in arrears and is not meeting their child support obligation, probation will, on your behalf, albeit slowly and sometimes not very efficiently, they will file an application to enforce that child support on your behalf, so you don't have to take that step to file for the enforcement of the order. So what happens if the other parent does not pay? What can the court do? Well, they have a variety, as you see, ways that they can sort of get that other parents to comply, or at least get some child support into the pocket of the other parent. They can intercept and garnish income tax refunds. They can revoke or suspend professional licenses, driver's licenses. They can intercept personal injury settlements. If there's a house being purchased, they have to do a search, a judgment search, to see if there's child support that's owed. Proceeds from a house can also be taken. Credit, it can be reported to a credit agency. They can be ordered to participate in a community service program. Worst case scenario, and probably last resort, is the incarceration or being jailed for failure to pay child support. Why is that? Well, because it's sort of a sword that cuts both ways. If a parent is put in jail and they lose their job for becoming incarcerated, then there's no money coming in, and they're certainly not going to be able to pay their child support. So courts try to avoid doing that. What I've seen most frequently is judges bringing in defendants in child support matters and saying to them, look, you owe $10,000. You better come up with $2,000 by the time I'm off the bench today. And if not, you're going to go to jail. And it's a Friday and nobody's going to see you until Monday. And usually, miraculously, they go out into the hall and find somebody, or have a family member, or come up with that lump sum to avoid going to jail. So again, these are just a list of various ways your child support order can be enforced, or you can obtain relief. So I'm going to stop now, and I'm going to turn it over to my wonderful colleague, Esther, who's going to talk to you about domestic violence. So take it away, Esther.
Thank you, Jen.
One real quick, Esther, just we had a couple questions regarding child support. So one of them does have to do with domestic violence. So I'm going to hold off on that one since you're going into domestic violence. But there was a question here. Does a parent, and Janet or Esther, either one of you may answer, must a parent follow lifestyles, for example, keeping kosher, keeping Shabbos during visitation? If kids are Orthodox Jewish, what happens if they don't respect the child's lifestyle?
Well, again, I would say that, when we talked about the big decision making and joint legal custody, one of them is religion. And that's very important to a lot of parents, and how their children are raised, and in what religion. I would say absolutely. And I can't imagine a situation where a court would say it's not in the best interest of the child to, practice the religion that, to which they are being raised. And you have, now that's something that I would absolutely say, make sure is put in a court order, or if you have an agreement, put that in an agreement. You can be as specific as you need to be, and we encourage all clients to do that because of situations such as this. A court order or an agreement should say, when the child is with the other parent, those religious observations should be kept to, because it is in the best interest of the child. I hope
Now,
that.
I will say I had a case where the parents initially had agreed upon godparents and then changed their minds about who the godparents would be once they split up. The court will not look to enforce that, not to that extent. The court can't choose which godparent is going to be the godparent of the child unless it was agreed upon by a consent order. And again, the court is very reluctant to get into that point. Eating because it's kosher, something like that, very different than saying, well, we have to agree that this is gonna be the godparent. So usually the best thing is to try to put as much as you can in a consent order. And if there's mediation, try to resolve it again through mediation and getting it in that order, because certain things the court would enforce, certain things they won't. The other question is how to get child support from a parent who resides in a different country. He has the green card and comes to the States often.
Yeah, that's a difficult jurisdictional question, unfortunately. One of the things that, and thank you for that question, because I was remiss in not saying earlier that when you need to file an application for child support or really anything in the family court, the court is going to ask you almost immediately, do you have a good address for the other parent? Because if you don't know where they're living, or they are unable to be served because of laws of another country, especially if you don't have a good address for the other parent, the court is not even going to take your application, because under constitutional law, the other parent has to have notice that there is something filed against them in court. And if you can't get them notice, then the court will not proceed with any application, which is very frustrating for parents who are trying to get child support and they can't show that the other parent is aware that they've even asked for the child support. And it leaves them really with, right, Angela, I would say like zero good option. The court, if you can get the paperwork to the other country where the other parent lives, that's great. But I would absolutely have some sort of either international mail receipt that you were able to get them those documents. Otherwise, the court's going to say on the day of your court date, the other parent's not here, and you have no way to show the court that you even let them know that that was happening. So we call it due diligence. Try your best to get whatever documents to that other parent. Try your best.
Thank you, Jen. Go ahead, Esther.
So I'm going to speak a little bit about domestic violence, the different forms that it can be manifested, the relief that you can seek from the court and what that process is like. So, domestic violence is a pattern of abuse and controlling behavior that is ultimately meant, right, to establish and to keep or maintain this control over someone else, right? And like I said, right, domestic violence comes in many different forms. People often like to, or automatically think that it's just physical abuse, right? That's what we hear mostly in the context of. But really it can come as verbal abuse, emotional abuse, physical abuse, and financial abuse, right? These are all forms of domestic violence. So, there is this, we have this power and control wheel, which is very helpful. Sometimes we can even use this in court as well. And it's very helpful to understand what the pattern of abuse and like violent behavior sort of looks like, right? And how one thing can lead to the other. So, there coercion and threats, intimidation, how that goes to emotional abuse, how that, isolates a person. And, again, it's very helpful to kind of map out what that looks like and how ultimately someone ends up taking control of someone else's life. So in terms of protections for survivors of domestic violence, right? There is the Prevention of Domestic Violence Act. This is what allows these different forms of relief. So what this act does, it allows victims to apply for a restraining order in a civil proceeding that prohibits the abuser from contacting the victim or returning to the scene of domestic violence. So basically, again, it's you're getting a restraining order, and it prohibits the abuser to from contacting the person who has gotten this restraining order. So how does the law, or what do we mean when we say survivor, right? Who does the court recognize as a survivor of domestic violence, right? And so the legal definition of a victim or survivor under the PDVA is a person who is 18 years or older, an emancipated minor. And emancipated just means someone who, is no longer under their parental control, and someone who has been subjected to domestic violence by a spouse or former spouse, a dating partner, a current or former household member, a person with whom the victim has a child in common, or a person with whom the victim anticipates having a child in common because the victim is pregnant. So again, this is what the court needs to see, or the judge needs to see, in order for you to be qualified as a victim or survivor of domestic violence. So how do you ultimately obtain a temporary restraining order, right? There are two ways. You can either go to your local police department, or you can obtain a temporary restraining order from a municipal court or superior court. And so, you can obtain one from the police department anytime after hours. If, an incident occurs on the weekend or a holiday, you'll go to your local police department, you'll get a judge or emergent judge on the phone. And if, you don't speak English, you can always have an interpreter, or an interpreter will be provided, right? So for the court, if you're seeking to get a temporary restraining order from the courthouse, you will have to go during regular business hours. Though actually, I think of right now, the courts are still closed, so you would likely call the courthouse, speak to the domestic violence unit, and let them know that you want to obtain a temporary restraining order, and then they'll go through the process. And then you'll likely appear before a judge or hearing officer. I'm not sure if it may be done perhaps via video or telephone. So they'll of course let you know how that'll be, but you will also have a right to an interpreter. So if you're not able to speak English, right, they will be able to provide one for you.
The courts are physically closed for the most part. However, for survivors of domestic violence, they have opened the courts so that during regular business court hours, some people feel more comfortable going in person. If you don't, there is a telephone number you can call. You can call the domestic violence unit for each courthouse, as well as all hearings are being held virtually. The only hearings that are not being held virtually is when a person just doesn't have the ability to appear via virtual, which is Zoom, like we're doing now, or Microsoft Teams, or the person, or it's an extensive case with a lot of evidence. And then the court tries to accommodate those types of hearings. But for the most part, everything is being done virtually.
Right. Okay, so for predicate acts, right? What is a predicate act ultimately, right? And it's really like the most recent incident, right? The most recent act that happened that made you want to apply for this temporary restraining order. So there are 19 different predicate acts of domestic violence under the PDVA, right? And so they're all listed there, right? It could be homicide, assault, terroristic threats, kidnapping. And you'll also see how this is actually laid out when you get your actual temporary restraining order. And, I believe we have a sample a little bit later on in the slideshow, and it'll be checked off, right? Once you tell them what happened, one or several of these predicate acts will be checked off in your temporary restraining order. And ultimately, right, you'll have to, if you decide to go with the process and apply for a final restraining order, these are things that you will have to show to the court, right, that happened. So thank you. So this is what your sample temporary restraining order looks like, right? It'll have the docket number. I think, I'm not sure if you can all see, it's very small, but there's a section there that says a police case number. If there's a number there, that usually means that there's a police report. So, if you're speaking to an attorney and they ask you, if there's a police report and you see there a number there, that means that there is one, right? And you may want to obtain a copy of that. It won't have your address, right? Of course, for safety reasons. And just to note where it says the defendant information, sometimes it will have their address, sometimes it'll just say confidential. And if it says confidential, that usually means that the person who you filed the temporary restraining order against has filed a temporary restraining order against you. And if that's the case, it'll likely say confidential on the address. Towards the middle, it says, it has the date and time of the predicate act. As I said, right, the incident that occurred that made you want to go get this temporary restraining order. It'll have a description of, what happened, the time. And as I said earlier, there's little boxes in the middle of the page that have listed the predicate acts. So these things will be checked off. And a little bit below that, it's also going to ask you essentially about prior history, right? What else has happened before? Any other domestic violence incidents that you can remember, right, should be listed there, should be reported. And again, there's just more information on the bottom, but then page 2 is, what is the relief, right? And it'll be checked off there, right? That the person is prohibited from returning to the scene of violence. They're prohibited from any future domestic violence. They are barred from the residence, right? If they're living with you, they're not allowed to come back. They're not allowed to go to your work. There's just really, there should be no contact, right? And so all of that should be checked off, right? There's also, if person has, or the abuser has any weapons, right, that will be seized. So they won't be able to have any weapons there. In page 3, you have, that's listed out there as well. If there are children involved, in part 2, it does say, right, no parenting time or visitation until further ordered, parenting time, visitation pursuant to, blank. It's suspended until, you go before a judge again and the judge clarifies, what visitation is going to look like. So, a lot of people often think that once there's a temporary restraining order, like the abuser will never see the children again, that's, it's done. It's, and that's not really always the case, right? Once you go before the judge and the process plays out, there's usually a order that is put in place, right? One that is able to protect you as a person who have got this temporary restraining order, final restraining order, but it also delineates what that parenting time will look like. So in terms of amending a temporary restraining order, right? As I pointed out in the page of the temporary restraining order where you can list out prior history, right, or prior incidents, if there are incidents that aren't listed there, right, anytime before the final restraining order trial, even including on the day of trial, right, you may be able to amend that complaint to include the additional incidents, right, which includes the applicable crimes, adding to or clarifying a predicate act, or adding to and clarifying prior history. So if there are other incidents, you definitely want to amend your TRO to include all of that. That'll definitely be a big component at your trial as well. So very important, due process does require that the defendant or the abuser be served with the amended complaint and that they be provided time to prepare a defense. So the final restraining order hearing, right? If you've decided that this is something that you want to pursue, the final restraining order hearing is a civil non-criminal proceeding that occurs in the family division of the Superior Court. It is a summary proceeding, so it's, supposed to be, or it's intended to be, short and concise. I'm sure the other attorneys who are here can tell you that it is not necessarily the case, especially now in the time of COVID, that things are drawn out and, unfortunately, things are kicked down the road a bit by judges. Or, you think you'll be done in a day and, the judge can't hear you until later in the day. And suddenly you have to go back in front of the judge a couple of times before you ultimately get that final restraining order. But just keep in mind that even if, that does happen, you still have your temporary restraining order in place. So you're still under the protection of that order, okay? And just a note as well, you may get several different documents in the mail, right? Some things will be related to this particular civil proceeding, and some other documents might be related to the criminal proceeding. Sometimes there are other criminal proceedings that are put in place, right, against the defendant. So just as a note. And last, because the hearing is supposed to be a quick and, a summary proceeding, discovery is not required, which just means you don't really have to exchange all of the evidence that you obtain to the other side.
Okay, and just so that we're clear, you do have to prove your case. So if you're granted a temporary restraining order, you still have to have a trial in order to try to obtain the final restraining order. It's not automatically given. So that you still have to prove the predicate act, the relationship that you have among the parties, and the continuing need for the final restraining order. In New Jersey, final restraining orders are indefinite. That means they never expire. They're on forever until you, the plaintiff, decides that you no longer require the protection of the final restraining order and you can apply to the court to have it dismissed. The defendant can file a motion, but they have to jump through hoops. It's not easy to get this dismissed, even years down the road. So it's extremely important that, unlike other jurisdictions in New Jersey, a final restraining order is pretty much forever, unless you, the plaintiff, says, I don't want this protection anymore.
So other sources of information, right? You can look at the New Jersey court rules and statutes. I know LSNJ and our organization does provide materials, on these topics, not just domestic violence, but of course, as Jen was talking about, things that relate to custody visitation, all of that. And of course, you can always contact our organization and speak to an attorney directly, right? To be able to provide you with more information and advice based on the specific facts of your case, right? This is just general information, depending on what is going on in your case, right? The attorneys will advise you accordingly.
There is a question, and I think this is very much in line of relief. When you apply for a restraining order, if the final restraining order is granted, you apply for relief. And what relief can you apply for? You can, depending on the circumstances, if the violence took place in front of the children, you can always ask for child support. You can ask outright. You can also ask for sole custody. Know that because unless the domestic violence took place in front of the child or it was extremely egregious, it is highly unlikely that you'll be granted sole custody, even with the domestic violence. What's sad is the New Jersey statutes, the New Jersey legislature did pass the Prevention of Domestic Violence Act, and in there it specifically says there's a correlation between child abuse and domestic violence. And even with that said, that's what we usually argue, to try to get visitation limited or supervised visitation or try to get sole custody. Most judges don't bite, and I'm so sorry to say that, and I cringe at the thought of it, but it's our reality. Our reality is that most judges will not, unless it's an egregious act, of violence or an act that took place in front of the children, they'll contact DCPMP, which is DIFUS, but it's highly unlikely that they will limit visitation, parenting time, or custody solely because they're granting you this final restraining order, which answers the first question that was asked. In terms of visitation, if a final restraining order is granted. The second question is, Esther and Jen, sometimes clients ask, have if they have gone when they have gone to to request a restraining order, what type of information should they give? Because sometimes they add that there's no child support in addition to the alleged abuse. So when they go either to the police department or to the court to try to get a restraining order, what kind of information should they be providing?
Yeah, I mean, my advice would be to provide as much as information as possible, right? What happened, if there are children involved, and as we went over the sample TRO, right, there are things that you can check off, right? If you're seeking child support, if you're seeking, visitation, all of these different things, right? You want to be able to provide as much information as possible. So,
But you should bear in mind that this is a restraining order. So what's the most important? The most important is the act of domestic violence that occurred along with any previous history. You are limited to testifying to what's in that restraining order. And that's why we mentioned the amendment portion, because quite often when you go to the police station, the police officers don't draft the restraining order the same way that the courthouse will, that hearing officers do in the courthouse. So they omit a lot of information. And you can only testify to what's in that restraining order. So previous history, whether reported or not, and when we say whether reported or not, solely because you did not call the police does not mean that you cannot include that incident of domestic violence in your restraining order. In fact, you should. The incidents of domestic violence must be included because otherwise you can't testify to them in trial.
Thank you so much, Angela. And I think if it's okay, we have more questions coming in, but like you said at the beginning, if we could keep the questions for when we meet again on the 11th, February 11th, that would be great, just because we're short on time. It's incredibly detailed, comprehensive information that you, Angela, and Jennifer, and Esther, you shared with us today. And for that, we really thank you. And I also want to ask for all our attendees if they can please fill out a survey that I just included into the chat. If you could follow the link on that survey and give us some of your feedback and let us know what other topics you might be interested in hearing about in the future, in future presentations. That would be really helpful to us. And so again, there's a link in the chat that was sent out. If you could please go there and fill that out, that would be very helpful. And we look forward to having you all, Angela, and I hope, and possibly Jennifer and Esther, coming back to share with us more about knowing our rights as it relates to the divorce process. So thank you all for coming today and joining us. And Angela, is there anything you want to add before we end?
No, I did put in the last slide was all of our contact information if people want to take it down for each specific county. We service Bergen County, Hudson County, or Passaic County, or if your legal issue takes place in one of these counties. Otherwise, we're not able to assist. There are legal services programs throughout the United States. I saw someone had a question about spousal support as it relates to New York law. We cannot advise as to other states' law in other states, but there are legal services programs and legal aid programs in other states that they can contact there to try to seek further advice. The last question here has to do with kidnapping children during visitation. If you believe that the father is going to take the children, you can put that, you can file an application with the court asking the court to instruct them. I mean, that's the most the court can do and say they violate the order, but there is something called the Hague Convention, which which means that it's an agreement between the United States and other countries. And so if your child is kidnapped to another country that's part of this agreement, the Hague Convention, then they will do everything possible to try to get your child back if your child is kidnapped. But it must be the country where the child is being kidnapped, has been kidnapped to, must be a part of that treaty. Otherwise, it cannot be enforced.
Thank you so much.
Thank
Thank
you.
you, everybody, for joining. And I put some information about Project S.A.R.A.H in the chat as well. Feel free to be in touch with us as well. And looking forward to meeting again February 11th.
Thank you so much, Shira.
Take care.